the legislative branch. Section 51. Law may not relate to more than one subject, to be expressed in title. Amendments must be at length. No law enacted by the General Assembly shall relate to more than one subject, and that shall be expressed in the title, and no law shall be revised, amended, or the provisions thereof extended or conferred by reference to its title only, but so much thereof as is revised, amended, extended or conferred, shall be reenacted and published at length. In addition to the enacting clause, each piece of legislation must contain a title, indicating the subject of all matters in the bill or resolution. No bill may relate to more than one subject, as expressed by its title. If a bill proposes to change an existing law, it must contain the text of that law and not simply the title of the act to be amended. The purpose of the constitutional requirements concerning the contents of legislation, which are also found in other state constitutions, is to give both legislators and the public adequate information about the matters actually being considered by the General Assembly. The framers of the Third Constitution in 1850 first provided that a statute should deal with only one subject, to be expressed in the statute's title, as it had been the habit of legislatures to that date to enact laws that treated more than one subject, much to the confusion of lawyers and the public at large. The framers of the current Constitution additionally prescribed statutory amendments by reference, another legislative habit that spread confusion. Instead of setting out the statute to be amended in full, legislative journals and the officially published acts only included the title of the statute and the words to be added or deleted. Unless one had access to the original text of the statute, it was impossible to comprehend the amendment. Section 51 requires the part of the statute that has been amended to be printed in full. The Kentucky judiciary has been relatively liberal in its interpretation of Section 51, holding that a statutory title need not contain all the details of the statute and that a subject in the statute that is foreign to the title may be eliminated without invalidating the remainder of the act, in Weimer v. Commissioners of Sinking Fund of City of Louisville, 1907. The courts have gone so far as to rule that a title that merely gives a clue to the statute's contents satisfies the requirements of Section 51, in Commonwealth v. Collins, 1986. Further, a subsection of a statute may be amended without republication of the entire section of which it is a part. Nor is it necessary for a statutory title to describe former statutes that have been repealed, in Bowman v. Hamlet, 1914, or for the body of the statute to set forth the language of the repealed statute. However, the Kentucky Supreme Court ruled in 1977 that Section 51 is not an ineffectual relic, in McGuffey v. Hall, 1977, and later decided that where the body of an amendment of a statute deals with a different subject than that indicated in the title, the amendment is unconstitutional, in Ferris v. Shoppers Village Liquors, 1984. Section 52. General Assembly may not release debt to state or to county or city. The General Assembly shall have no power to release, extinguish or authorize the releasing or extinguishing, in whole or in part, the indebtedness or liability of any corporation or individual to this Commonwealth, or to any county or municipality thereof. The previous three constitutions did not contain a section similar to this, and the General Assembly, especially during the period of the Third Constitution, occasionally forgave or compromised indebtedness by special and local legislation. The Kentucky judiciary has held that an unliquidated or disputed claim against the state or a locality may be compromised, but a fixed and certain liability may not, in Steele v. Taylor, 1937. Thus, a city cannot make a compromised settlement of taxes where the amount was not disputed, in City of Louisville v. Louisville Railway Company, 1901, but it can compromise a judgment pending an appeal, in Cole v. Burton, 1950.
Section 53. Investigation of accounts of Treasurer and Auditor. Report, publication, submission to Governor and General Assembly. The General Assembly shall provide by law for monthly investigations into the accounts of the Treasurer and Auditor of public accounts, and the result of these investigations shall be reported to the Governor, and these reports shall be semi-annually published in 2 newspapers of general circulation in the state. The reports received by the Governor shall, at the beginning of each session, be transmitted by him to the General Assembly for scrutiny and appropriate action. The framers of the current Constitution inserted this provision in response to the discovery in 1888 of the embezzlement of $247,000 from the Commonwealth by State Treasurer James W. Honest Dick Tate and the failure of the state auditor to have periodically audited Tate's accounts. According to the Kentucky Court of Appeals, an additional purpose was to provide the General Assembly and the governor with data upon which to base appropriations and taxation in State Budget Commission v. Lebus, 1932. Section 54. No restriction on recovery for injury or death. The General Assembly shall have no power to limit the amount to be recovered for injuries resulting in death, or for injuries to person or property. There was very little debate on this section, which first appeared in the current Constitution. The chair of the committee that drafted the section asserted that the legislature in some cases had limited the amount of damages recoverable from railroads for negligently caused injuries or deaths, perhaps in reference to successful efforts of the railroad lobby to defeat legislative attempts to expand the beneficiaries of the wrongful death statute beyond the immediate family of the deceased. Section 54, together with Sections 14 and 241, has undermined recent efforts at tort reform. For example, the Kentucky Supreme Court invalidated a statute that made it much more difficult to secure punitive damages in personal injury cases on the grounds that the legislation sought to diminish a right established prior to the adoption of the current Constitution, in Williams v. Wilson in 1998. A statutory 5-year limitation on malpractice suits against surgeons, other physicians, dentists, and hospitals, in McCullum v. Sisters of Charity of Nazareth Health Corporation, 1990, and a similar limitation on tort actions for personal injuries caused by a deficiency in the construction of any improvement to real property in Saylor v. Hall, 1973. In 1991, the court invalidated a statute of repose that cut off a right of action against builders and material suppliers arising from the use of defective products after the expiration of 7 years following the completion of construction and, in so doing, declared that Section 54, together with Sections 14 and 241, protected rights of action for damages for death or injury caused by negligence established after the adoption of the current Constitution, as well as those created before. In Perkins v. Northeastern Log Homes in 1991. Previously, the judiciary had ruled that if an action did not exist under common law when the current Constitution was adopted, the General Assembly may limit or abolish it. Thus, it upheld a blood shield statute, which barred strict liability actions for blood and blood products transactions, since an action for strict product liability had not been established in Kentucky by the date of the adoption of the current Constitution, in McKee v. Cutter Laboratories, 1989. And a statute that barred the liability of owners of real estate to trespassers for non-intentionally caused injuries, such as when a 15-year-old boy climbed an electrical tower and was injured by arcing electricity, because there was no liability for such injuries in 1891, in Kirshner v. Louisville Gas Electric, 1988. The judiciary invalidated Kentucky's first Workers' Compensation Act because it limited liability for job-related injuries, required workers to be covered by the statute, and thus denied them the right to sue at common law to recover possibly greater damages, in Kentucky State Journal Company v. Workmen's Compensation Board, 1914, but it upheld a successor statute because, although it also limited liability, it gave workers the option of electing not to be covered, in Green v. Caldwell, 1916. The Special Commission on Constitutional Review of 1987 recommended that Section 54 be amended to authorize the General Assembly to limit the amount to be recovered for non-economic loss, punitive damages, and all other non-pecuniary damage arising from injuries resulting in death, or from injuries to person or property, noted in Report of the Special Commission on Constitutional Review.
Section 55. When laws to take effect. Emergency legislation. No act, except general appropriation bills, shall become a law until 90 days after the adjournment of the session at which it was passed, except in cases of emergency, when, by the concurrence of a majority of the members elected to each house of the General Assembly, by a yea and nay vote entered upon their journals, an act may become a law when approved by the governor, but the reasons for the emergency that justifies this action must be set out at length in the journal of each house. The framers of the current Constitution added this provision to provide time for Kentucky's citizens to become aware of newly enacted laws before they went into effect. although the Kentucky judiciary did on one occasion decline to look into the reasons why the General Assembly had inserted an emergency clause into certain legislation, in Hill v. Taylor, 1936, on another earlier occasion it did investigate and invalidated such a clause when the reasons set forth in the legislation did not indicate an emergency, in McIntyre v. Commonwealth, 1927. Section 56. Signing of bills. Enrollment. Presentation to Governor. No bill shall become a law until the same shall have been signed by the presiding officer of each of the two houses in open session. And before such officer shall have affixed his signature to any bill, he shall suspend all other business, declare that such bill will now be read, and that he will sign the same to the end that it may become a law. The bill shall then be read at length and compared. And, if correctly enrolled, he shall, in the presence of the House in open session, and before any other business is entertained, affix his signature, which fact shall be noted in the journal, and the bill immediately sent to the other House. When it reaches the other House, the presiding officer thereof shall immediately suspend all other business, announce the reception of the bill, and the same proceeding shall thereupon be observed in every respect as in the House in which it was first signed. And thereupon the clerk of the latter House shall immediately present the same to the Governor for his signature and approval. The framers of the current Constitution added this provision in response to allegations that on at least one occasion a statute contained provisions not part of the approved bill but instead added by the enrolling clerk after the Senate had voted on the legislation. Governor Simon B. Buckner, a delegate to the 1890-1891 convention, asserted that on another occasion he was presented with two different versions of a bill, one signed by the Speaker of the House and the other by the Speaker pro tempore. A third recounted incident involved the removal of some of the pages of an approved bill and the substitution of other pages that completely altered the purpose of the bill between the time of the bill's passage and its presentation to the enrolling clerk. This section was added to prevent the future occurrence of such incidents and to ensure that the language of enacted laws was the same as that of approved bills. This section has been the subject of very few published adjudications, the most sensational of which involved Lieutenant Governor Albert B. Happy Chandler, who as presiding officer of the Senate refused to sign a bill approved by both houses. The Kentucky Court of Appeals invalidated the law because Chandler had not signed it even though it had been signed by the governor, and Chandler's reasons for not signing it were in error, in Kavanaugh v. Chandler, 1934.
Section 57. Member having personal interest to make disclosure and not vote. A member who has a personal or private interest in any measure or bill proposed or pending before the General Assembly shall disclose the fact to the House of which he is a member, and shall not vote thereon upon pain of expulsion. The authority of each member of the General Assembly to vote on matters before his or her chamber is limited by one provision of the Constitution. In recognition of the fact that Kentucky legislators are part-time officials who may have private interests that are in conflict with those of the general public, the Constitution requires a member with a personal or private interest in any measure proposed or pending before the General Assembly to disclose that fact to the other members of his or her chamber and abstain from voting on the measure. The penalty prescribed by the Constitution for failing to disqualify oneself in such instances is the threat of temporary expulsion. Each chamber of the General Assembly has the power to expel a member by a two-thirds vote, but only once for the same reason, according to Section 39. The section first appeared in the current Constitution, and was a reflection of the perception of the framers that previous legislators sometimes had voted for legislation that had benefited them personally. Few decisions about this section have arisen. The Kentucky Court of Appeals ruled that the section did not invalidate a veterans bonus statute that had been voted on by legislators who were veterans, in Stovall v. Gartrell, 1960. And the Attorney General issued an opinion that lawyer legislators could validly vote on legislation affecting the legal profession. Section 58. General Assembly not to audit nor allow private claim. Exception. Appropriations. The General Assembly shall neither audit nor allow any private claim against the Commonwealth, except for expenses incurred during the session at which the same was allowed, but may appropriate money to pay such claim as shall have been audited and allowed according to law. This is another section not found in previous constitutions, which reflects the general desire on the part of the framers to curtail the practice of legislators of approving private claims against the Commonwealth that had not been properly audited. The Kentucky judiciary, in the few cases adjudicated about this section, has consistently held that the legislative approval of expenses incurred in the performance of public duties does not violate this section. Thus, the Kentucky Court of Appeals upheld a legislative appropriation to compensate the state treasurer for monies a court ordered him to pay because he had, in a good faith, but mistaken, interpretation of the law, authorized expenditures in excess of his budget, in Finance Department versus Dishman. 1944, it also upheld a legislative appropriation to reimburse a sheriff for expenses incurred in the apprehension in Idaho of a person under indictment for murder in Kentucky, in Pennington versus Shannon, 1937.
Section 59. Local and special legislation. The General Assembly shall not pass local or special acts concerning any of the following subjects, or for any of the following purposes, namely, first, to regulate the jurisdiction, or the practice, or the circuits of the courts of justice, or the rights, powers, duties or compensation of the officers thereof. But the practice in circuit courts in continuous session may, by a general law, be made different from the practice of circuit courts held in terms. Second, to regulate the summoning, impaneling, or compensation of grand or petit jurors. Third, to provide for changes of venue in civil or criminal causes. Fourth, to regulate the punishment of crimes and misdemeanors, or to remit fines, penalties, or forfeitures. Fifth, to regulate the limitation of civil or criminal causes. Sixth, to effect the estate of Cestuous K. Trust, decedents, infants, or other persons under disabilities, or to authorize any such persons to sell, lease, encumber, or dispose of their property. Seventh, to declare any person of age, or to relieve an infant or femme covert of disability, or to enable him to do acts allowed only to adults not under disabilities. Eighth, to change the law of descent, distribution, or succession. Ninth, to authorize the adoption or legitimation of children. 10th, to grant divorces. 11th, to change the names of persons. 12th, to give effect to invalid deeds, wills or other instruments. 13th, to legalize, except as against the Commonwealth, the unauthorized or invalid act of any officer or public agent of the Commonwealth, or of any city, county or municipality thereof. 14th, to refund money legally paid into the state treasury. 15th, to authorize or to regulate the levy, the assessment or the collection of taxes, or to give any indulgence or discharge to any assessor or collector of taxes, or to his sureties. 16th, to authorize the opening, altering, maintaining or vacating of roads, highways, streets, alleys, town plats, cemeteries, graveyards, or public grounds not owned by the Commonwealth. 17th, to grant a charter to any corporation, or to amend the charter of any existing corporation, to license companies or persons to own or operate ferries, bridges, roads or turnpikes, to declare streams navigable, or to authorize the construction of booms or dams therein, or to remove obstructions therefrom, to effect toll gates or to regulate tolls, to regulate fencing or the running at large of stock. 18th, to create, increase or decrease fees, percentages or allowances to public officers, or to extend the time for the collection thereof, or to authorize officers to appoint deputies. 19th, to give any person or corporation the right to lay a railroad track or tramway, or to amend existing charters for such purposes. 20th, to provide for conducting elections, or for designating the places of voting, or changing the boundaries of wards, precincts or districts, except when new counties may be created. 21st, to regulate the rate of interest. 22nd, to authorize the creation, extension, enforcement, impairment or release of liens. 23rd, to provide for the protection of game and fish. 24th, to regulate labor, trade, mining or manufacturing. 25th, to provide for the management of common schools. 26th, to locate or change a county seat. 27th, to provide a means of taking the sense of the people of any city, town, district, precinct or county, whether they wish to authorize, regulate or prohibit therein the sale of vinous, spirituous or malt liquors, or alter the liquor laws. 28th, restoring to citizenship persons convicted of infamous crimes. 29th, in all other cases where a general law can be made applicable, no special law shall be enacted. Increasingly during the period of the Third Constitution, 1851 to 1891, the General Assembly devoted most of its time to the enactment of special and local legislation designed to deal not with the problems of the Commonwealth as a whole, but with the needs of individuals and localities. Special legislation included statutes that allowed individual women and children to conduct business as male adults, extended the time for individual sheriffs to settle their tax collection accounts, and chartered corporations. Local legislation authorized such matters as county seat and boundary changes, special county and city elections on whether to invest in railroad projects, and special penalties in certain counties for certain crimes. Usually the membership deferred to the individual legislator seeking the special or local law, a reality that, together with the multiplicity of such legislation, meant that these statutes were hastily considered and not always well drafted. Further, the General Assembly devoted so much time to this enterprise that it could not adequately deal with the pressing problems of the entire state that required general legislation. Moreover, the epidemic of local laws meant that there were different penalties for different crimes in different counties, a variation that compounded the statutory knowledge lawyers and judges needed to acquire for practice and adjudication in these counties. The framers of the current Constitution asserted that the public was more aroused over the evils of special and local legislation than almost any other problem, thus leading to the call for a constitutional convention. In order to fashion a constitutional prohibition on most special and local legislation, the drafters of Section 59 not only addressed specific categories of such legislation that had been routinely enacted by the Kentucky legislature, they also borrowed language from recent constitutional revisions of other states, which were also addressing the problem. The first 28 sections prescribe specific categories of special and local legislation, while Section 29 represents a more general prescription. Section 59 has been the subject of more published appellate court adjudication than any other section applying to legislative powers. The Kentucky Supreme Court has declared that the primary purpose of Section 59 is to prevent special privileges, favoritism, and discrimination and to ensure equality under the law. The court has held that Section 59, together with Sections 2 and 3, embrace the equal protection guarantee beyond what was provided in the 14th Amendment of the Federal Constitution. And that Section 59 invalidates a statute immunizing from personal injury persons who designed, planned, supervised, inspected or constructed improvements to real property after the expiration of 5 years following the completion of the improvement, in Tabler v. Wallace, 1986. In order for a law to be general and not special, and thus in violation of Section 59, the classification must be reasonable and apply equally to all persons in a class. Applying that standard, the court ruled that a workers' compensation statute that contained subclassifications of black lung disease based on the severity of the disease did not violate Section 59, in Kentucky Harland Coal Company v. Holmes, 1994. Reconciling Sections 59 and 60 with Section 156, which permits the legislative classification of cities, the Kentucky Court of Appeals has held that such classification must pertain to the organization or government of cities and that a statute prohibiting pool rooms and bowling alleys of fourth-class cities to sell liquor bears no such relationship, and thus violates Sections 59 and 60, in Manini v. McFarland, 1943. However, the court has held that a state statute exempting pension income of federal and state governmental retirees from state income taxes does not violate Section 59. In Commonwealth, Revenue Cabinet v. Cope, 1994. The Kentucky judiciary has likewise upheld a statute providing aid to dependent children, in Meredith v. Ray, 1942, and an exemption to the state's anti-gaming statute for pari-mutuel betting on horse races, in Commonwealth v. Kentucky Jockey Club, 1931. On the other hand, the courts have declared the state's Uniform Residential Landlord and Tenant Act to be in violation of Section 59 because it only applied to cities of the first class and urban county governments, in Miles v. Shanti, 1983, and also struck down a statute providing for the pretrial suspension of the driver's license of persons under the age of 21 who are arrested for drunk driving, in Commonwealth v. Raines. 1993.
Section 60. General law not to be made special or local by amendment. No special powers or privileges. Law not to take effect on approval of other authority than General Assembly. Exceptions. The General Assembly shall not indirectly enact any special or local act by the repeal in part of a general act, or by exempting from the operation of a general act any city, town, district or county, but laws repealing local or special acts may be enacted. No law shall be enacted granting powers or privileges in any case where the granting of such powers or privileges shall have been provided for by a general law, nor where the courts have jurisdiction to grant the same, or to give the relief asked for. No law, except such as relates to the sale, loan, or gift of vinous, spirituous or malt liquors, bridges, turnpikes or other public roads, public buildings or improvements, fencing, running at large of stock, matters pertaining to common schools, paupers, and the regulation by counties, cities, towns or other municipalities of their local affairs, shall be enacted to take effect upon the approval of any other authority than the General Assembly, unless otherwise expressly provided in this Constitution. The framers of the current Constitution added this section to ensure that the General Assembly did not create special or local legislation by the amendment of general legislation, or by inserting exemptions therein. This section prohibits the creation of special or local laws by providing exemptions in general laws, or by repealing a part of them. It also prohibits the delegation of power by the General Assembly except in certain specified areas, including the regulation of local affairs by counties, cities, and towns. The framers believed that while the General Assembly should not be enacting laws regulating local affairs, cities and counties should have that power generally and in specified cases such as bridges, turnpikes, liquor, fencing, and common schools. The Kentucky Court of Appeals held that an amendment to a compulsory primary statute exempting party candidates for statewide offices did not render the statute unconstitutional, in violation of Section 60, by creating a special act or by delegating legislative power to private citizens, in Stevenson v. Hardin, 1931. The Kentucky Supreme Court has likewise held that a statute exempting senior officers of county police forces of counties with a population exceeding 600,000 from the county police merit system does not violate Section 60, in Jefferson County Police Merit Board v. Bilyeu, 1982. However, the Attorney General has issued an opinion that a statute that exempts church-sponsored day care centers from its requirement that child care centers must request sex crime records for employee applicants constitutes special legislation in violation of Section 60. The Kentucky Court of Appeals has held that the General Assembly may delegate legislative power to administrative agencies if it establishes policies and standards by which such power is to be exercised. Thus, a delegation of power to a board to establish minimum wages for women and children satisfied this test, in Young v. Willis, 1947. However, an act that delegated rulemaking authority to mine operators, with such rules to be approved by a mine inspector, was held to represent an unconstitutional delegation of legislative authority in violation of Section 60 in Anderson's Administrator v. Granville Coal Company, 1924.
Section 61. Provision to be made for local option on sale of liquor. Time of elections, the General Assembly shall, by general law, provide a means whereby the sense of the people of any county, city, town, district or precinct may be taken as to whether or not spirituous, vinous or malt liquors shall be sold, bartered or loaned therein, or the sale thereof regulated. But nothing herein shall be construed to interfere with or to repeal any law in force relating to the sale or gift of such liquors. All elections on this question may be held on a day other than the regular election days. The framers of the current Constitution added this section at the revisory session of the Constitutional Convention of 1890 to 1891, following the popular ratification of the Charter. They acted in response to complaints from temperance forces that the new Constitution was pro-liquor because of Section 59, subsection 27, which forbade the General Assembly from enacting local or special laws to provide a means of taking the sense of the people of any city, town, district, precinct or county, whether they wish to authorize, regulate or prohibit therein the sale of vinous, spirituous, or malt liquors, or alter the liquor laws. In the decades immediately preceding the Constitutional Convention of 1890 to 1891, temperance forces had persuaded the General Assembly to enact numerous special laws authorizing local option elections that were mostly won by the Prohibitionists, who were becoming a major political force in the Commonwealth. To ensure the sanctity of local option, the delegates added Section 61, which required the General Assembly to enact a general law authorizing local option elections should the citizens of cities, towns, counties, districts or precincts so desire. In 1892, shortly after the new Constitution went into effect, the General Assembly passed such a law, and it passed a similar law in 1894. In November 1919, voters repealed Section 61 when they approved an amendment to the state constitution, Section 226A, that prohibited the manufacture, sale, or transportation of alcoholic beverages within the Commonwealth. However, in November 1935 they expressly revived Section 61 when they repealed Section 226A. The Kentucky Court of Appeals held that the Local Option Statute of 1894 gave to each city, town, district, and precinct the authority to control the liquor traffic within its territory, in Cole v. Commonwealth, 1897. In 1907, the court upheld the County Unit Law of 1906, which gave the voters of a county the right to prohibit liquor sales countywide, in Board of Trustees of Town of New Castle v. Scott, 1907. In 1915, the court upheld an amendment to the county unit law that brought certain previously exempted cities and towns of the first four classes within its mandate, in Young v. Trimble. In 1948, the General Assembly reinstated the exemption for cities and towns of the first four classes. The Kentucky Supreme Court held in 1985 that under the amended county unit law, a local option election may not be conducted in a magisterial district that is located within a county that has voted in favor of prohibition, in Howard v. Salyer, 1985.
Section 62. Style of laws. The style of the laws of this Commonwealth shall be as follows, be it enacted by the General Assembly of the Commonwealth of Kentucky. The Constitution establishes several requirements concerning the form of laws enacted by the Kentucky General Assembly. Each bill must contain an enacting clause reading, be it enacted by the General Assembly of the Commonwealth of Kentucky. Bills passed without this clause have been ruled void. However, a slight difference in the words prescribed for the enacting clause, such as substituting legislature for General Assembly, will not necessarily invalidate a law. As in this section, previous Kentucky constitutions and the Constitution of the federal government and of most states require that all statutes contain an enacting clause. The provision of this section as to the style of laws is mandatory, and an act relating to passenger rates that contained no enacting clause was held void, in Commonwealth v. Illinois Central Railway Company, 1914. The fact that an act relating to fire regulation used the word legislature in its style instead of General Assembly did not invalidate the act, as Section 62 requires substantial, not literal, compliance, in Louisville Trust Company v. Morgan, 1918.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.